Okay, well, welcome everybody to our Lunch and Learn series. Today is on civil litigation, and I have put the agenda in the chat box, and I'll repost it in a couple of minutes for anyone who has come in later who hasn't been able to see it. But today, we are just to go over some housekeeping things. You do not need to send me your bar number. We now get it when you register, so do not worry about that. There will be, if you haven't been to one of our Lunch and Learn or virtual CLEs, there will be 2 polls during the CLE, and they will not be announced. So please look out for them, and you will just answer yes that you're still participating. Because those reports have to be given to the CLE Commission. And these CLEs are free for Charleston County Bar members. So if you are registered and you are not a Charleston County Bar member, you will not get credit. So if you sit through the CLE, your name won't be on the list that we submit to the CLE Commission. So please reach out to Kim Steele at, I apologize, at the bar. Sorry, y'all, I am working from home. But if y'all will please reach out to Kim Steele at the bar at secretary@charlestoncountybar.org to make sure that you are a CCBA member, that would be great. I have posted the agenda, like I said earlier. We do not have the course number yet. The CLE Commission is behind on their course approval, but hopefully when the email goes out from Zoom for the registration, probably in a couple of days, we should have the course number in that email. And if not, you will get a separate email with the course number. And I think that that is all of the housekeeping items. If you have any questions for Sean or Kenny, you can put them in the Q&A or in the chat, and we will go through those at the end. And now for today's presentation, we have Developing and Maintaining Good Client Relationships, presented by Sean M. Wilson and Kenny L. Gardner. Sean and Kenny both graduated from the College of Charleston in 2008, and they both graduated from the Charleston School of Law in 2011. Kenny practices defense for Butler and Snow, and Sean practices on the plaintiff's side at the law offices of Sean M. Wilson. And let's give them a warm welcome, and we're excited to hear your presentation.
Thank you. Thank you for the introduction. I appreciate it, Mary.
Thank you, Mary.
Good morning, everybody. My name is Sean Wilson, and I'm here with my good friend, Mr. Kenny Gardner. We really appreciate you guys taking the time to hear us speak, and hopefully we're able to give you a little bit of insight from our perspective. I'm going to share the screen, and we're going to speak jointly from a PowerPoint presentation now, and we're going to make this more of a conversational style from a plaintiff's perspective and from a defense perspective.
And it's going to focus, as the title indicates, on developing and maintaining good client relationships. A lot of these things are similar between both sides of the bar, on the plaintiff's and the defense side, but there's some unique aspects to each, depending on the type of client that you have. In a lot of cases, with personal injury, the plaintiff's going to be an individual person, and on the defense side, it's either going to be an insurance company, some other corporation, or it could be an individual. So there are very different ways to kind of approach it, depending on which side you are. So we kind of just wanted to give you an overview of how we do it, and the importance of following the rules of professional conduct.
And so, Kenny, if you kind of introduce yourself and kind of tell them a little bit of your background, and I'll go on.
As Mary indicated, my name is Kenny Gardner. I'm at Butler Snow. It's a new defense firm here to South Carolina. We opened up our Charleston office, and it's our only office in the state, in 2019. The firm is headquartered in Ridgeland, Mississippi, but our footprint is all across the United States, and we have offices in London and Singapore. I do a lot of general defense, a lot of insurance coverage work, a lot of corporate defense, and things of that nature. The insurance company is a unique type of client. There's a lot of kind of not only the rules of professional conduct that you have to follow, but each insurance company has their own kind of unique rules and guidelines that they want you to follow. And the faster you get used to that and the faster you adapt to that, the better your relationship with those types of clients would be.
And I'm Sean Wilson. I recently opened up on Calhoun Street, but I've been on my own since April of 2018. I'm a plaintiff's lawyer here in Charleston, and I practice throughout all of the 46 counties if necessary, but primarily here in Charleston and Tri-County area. Work in personal injury. As Mary Lee stated earlier, went to the College of Charleston, went to Charleston School of Law. Kenny and I graduated both in 2011 together. I do some adjunct professional teaching there as well. Today, we're going to talk to you a little bit about our practice areas, managing the expectations from a plaintiff's perspective. Kenny's going to chime in on managing expectations from a defense perspective, communication, which is so important with the clients, some advice that we usually have to give, things that a plaintiff's lawyer should give, and then Kenny's going to talk about some things that a defense lawyer would do, social media perspectives from both of our vantage points for our clients, some trends in litigation from rideshare liabilities. Kenny can talk to you about how he sees it from a defense perspective. I can talk to you about it from a plaintiff's perspective. Recent trends, a lot of the new litigation is coming from COVID, and any questions at the end for you. So I deal with auto accidents, trucking accidents, a lot of personal injury, wrongful death, some comp and business litigation. And Kenny,
I do a lot of insurance coverage work, first party work, third party work, corporate defense, contract defense litigation, construction litigation, a mass tort such as your Johnson and Johnson litigation, things like that. Med mal cases, really the whole works. And I've even do some plaintiff's work, but that's very few and far between.
so when it comes to professional conduct, it's very important that you familiarize yourself with the rules in South Carolina on professional conduct. I look at it as one of my, I quote unquote, Bibles of several books that I have, along with the rules of civil procedure, that I'm trying to make sure that I'm always checking myself. From a plaintiff's perspective, we have to be careful because we are managing our escrow, our trust accounts. That has to be managed and operated to a T, or a science, I should say, and making sure that I am being a thorough and sincere counselor to my clients, that I do not want to violate any of those particular rules. And that's very important. So I'm always governing the correspondence that goes out. Mistakes happen, but I always want to make sure that I'm looking at those things, checking conflicts, making sure that the rules and I'm shepherdizing and making sure that I'm not citing old law, breaking things down so that there's an understanding for my client, answering any questions that they might have, and making sure that not only myself is familiar with the clients, but also that my staff is familiar with the clients, and so that we all have an understanding on who we represent, making sure that they have a comfortability with us, making sure that they know that everything that we talk about is confidential for them. So protecting that. I usually like to make sure that the copies of everything gets over to the clients, and if they want more, then I like to make sure that I have those copies ready for them.
from the defense perspective, and I think this goes to whether or not you do plaintiff's work or defense work, as Sean said, the rules of professional conduct are the foundation to any client relationship that you have. Everything's going to flow from that. It's important not only that you are really familiar with them, but your clients need to be familiar not with exactly what the rules say, but the concepts of, hey, I'm going to communicate with you in a reasonable fashion. I represent you, so I work for you. I will do my best to advocate for you, except where it would cause some kind of ethical conflict or other business conflict that you can't get out of. But they need to know these things, and your fee arrangements, all of those things, because it's the beginning of all things. And it's going to flow through not only that relationship, but every relationship that you have. And the difference is, at least from a defense perspective, are kind of minute. For instance, my clients generally don't meet my entire staff. They meet the folks who are staffing that particular case. And with regard to insurance companies, most of them require that you get whoever it is going to bill to that file approved. So, a lot of it is, whether there's a partner and an associate on board, a paralegal, anyone who bills to the file, the client needs to be at least aware of. And you get more familiar with them as you work through that case and cases in the future. Equally with your trust accounts and things like that, it's the same on the defense side. I work for a larger firm, so we of course have a team that handles all those things, but you still need to be very careful about what it is that you are doing with those monies, and how you just generally conduct yourself, not just with your client, but with the other side. I have found that I've gotten more cases resolved with attorneys that I've built relationships with, like Sean or any other number of plaintiffs' lawyers across the state, because it's a small bar. And so you generally get to know one another, and you get to know the reputation and the conduct of each other. And it's a very friendly bar. And a lot of people who are outside of this state do not understand that. And the congeniality of our bar is foreign to a lot of different clients. And so sometimes part of your job is to advise them that, hey, I've dealt with this lawyer before, we've built a rapport, I can do this, I won't do that, because
Hey guys, sorry to interrupt you. I tried to message y'all, but the sound is going in and out. It was fine for a little bit, but now it's back to going in and out again. I don't know if you can adjust where the microphone is.
Yeah.
Sorry.
Is that any better?
No, it's going in and out.
How about now?
Yeah, keep talking for a little bit. I'll let you know. Sorry to interrupt y'all.
No, that's okay. Apologize for the difficulty, but having those relationships with opposing counsel.
It's still going in and out, y'all. I'm sorry.
Let me pause for a second.
I'm mute, see that, guys. Again, sorry for the technical difficulties.
Let me put the PowerPoint.
That's better.
Okay. But again, how you carry yourself and how you conduct yourself with the lawyer on the other side is just as important in building those relationships with clients. Because if you have a good relationship with those other members of the bar, you can get a lot more done for your client. You can be much more effective. Going back to what, the rules of professional conduct being the foundation of building those client relationships. I mean, the more that you show your client that you're competent in your practice and, the status of the law, procedurally, all of those things, the more that you will endear yourself to them and they'll use you. The more that you communicate with them and let them know, hey, where their case is at, give them status updates, answering whatever questions that they might pose to you, it builds trust with that client. And I found that more times than not, that if you build those kind of basic fundamental things, you have a lot more repeat business. And from a more, the ground floor of, hey, how does one get clients on the defense side? We don't have a lot of just walk-in business. A lot of times it's folks that you meet through, different marketing opportunities, certain events across the country. Of course, just like the plaintiff's bar, the defense bar has all kinds of seminars. So you get to know and you get to present to folks who are in-house at certain companies or at insurance companies. And you also, what I found is, through the bar and personal referrals. So, you might not practice, one field of law, but you might know someone, one of your colleagues on the bar that does. And so, you tell your client, who that person is, and they reach out. Also, what I found lately with the change in law firms, particularly defense firms, how they're starting to kind of centralize, and the big firms are kind of coming in and I don't want to say taking over, but making their presence bigger. So a lot of times you end up being local counsel for national counsel. So a lot of times other lawyers are your clients. And so you have to also build that relationship with them. And again, through marketing opportunities, through writing, publishing, presenting, all of those things kind of just to get your name out there will benefit you in building your book of business.
Can you guys see our PowerPoint slide?
We can see it.
For me, from a plaintiff's perspective, I think that the biggest thing, from a plaintiff's perspective, Kenny, I think that we're in a situation where we're in a customer service-based business. We're providing a service, but we're coming from a customer service based business where customer service is key. And I think that it's the most important thing that we can provide. A lot of times I find myself thinking that what I do from a plaintiff's perspective is more keeping the client happy or managing the client expectations more so than actually engaging in trial preparation sometimes. You know, some of my biggest battles I find is talking to my clients and
Right.
making them have an understanding and making them have a communicational dialogue with me. Sometimes reaching them or sometimes getting them to a point to understand the severity of it. And so a lot of that, from my vantage point, comes from the lack of trust that people have with attorneys, especially the lack of trust that I feel that, you know, people have from plaintiffs' attorneys. And the key for me is to try to sit down and figure out, when I'm meeting with this client, how do I earn their trust and confidence?
Right.
Because what I feel is that a lot of what they do is they don't really trust us, so they're trying to figure out.
Right.
And getting them to a comfortability level is important. So I try to build common ground with them, try to get to know them on a personal level, letting them know how the process is going to be, at least an outline from start until actual finish of what they should expect. Being authentic, you know, letting them know who we really are, going over all of the documents that they sign, giving them realistic expectations. A lot of times, along with the customer service aspect of it, is the expectational aspect of it. What should I get? What do I know? How is this result going to be? And from a plaintiff's perspective, I think what their expectations are is something that I have to sit down and manage. And I undersell because I just don't know. Sometimes it's early on and clients will call you and they will ask you these questions, but I try to undersell as much as I can because I can't guarantee anything.
Right. I mean, and any lawyer, we all know that you can't guarantee results. Even if you feel like you can, you probably shouldn't. I don't even like to do the, hey, well, what's the percentage of this or that happening? And back to your point, Sean, it's all the customer service business. Any job you have, whether it's, a waiter or a waitress, or, you're working at Best Buy or in any kind of other retail, it's all about customer service. That's how you get repeat business. Now for attorneys, that's, that times 1,000, because we basically have a advanced degree in communication. And so a lot of what we do from the defense perspective is, like you said, helping them understand the process, but also communicating in a way that they may require, because certain insurance companies require certain reports. Your adjuster that you're dealing with, or your in-house counsel that you're dealing with, usually has a couple folks above them that have to give approval or have to see things. And so your manner of communication is so important, because it differs from client to client. And if you're communicating in a way, either A, that they don't understand, or B, that's not in line with their guidelines, then you might as well not be communicating at all. And it's those type of bad customer service experiences that cause clients to go elsewhere. The bar is growing. Certainly law school attendance is higher than it was 10 years ago, 20 years ago. And so there are a lot of available lawyers. And these companies know that they have the leverage. And so you have to communicate properly and effectively, and provide that good customer service. And because we can't guarantee results, that good customer service isn't always the result. A lot of times it's the journey to the result, whether it's a settlement or whether it's a trial. If they know that they can trust you, a result is less important. So, hey, we didn't win this one, but we fought it hard and we did everything that we could for you. And I found that as long as they walk away feeling like that, there's a good chance of them coming back.
And I think, Kenny, one of the things that clients don't really understand is that the insurance company is not my enemy. You on the other side, when I work a case against you, you are not the enemy. And that having a cordial relationship with you is very important. Giving you that extension that you might need in time, or you granting me that extension that I may need, is that we have a duty of civility amongst each other that we must make sure that we continue to do. Although we are zealously advocating for our clients, we do have to make sure that we have a civil, cordial relationship with each other.
Right. And, that goes back to the rules of professional conduct, and how you carry yourself with opposing counsel is just as important as how you carry yourself with your client. Any litigation can be personal. If a personal injury, if I've hurt myself or if you've hurt me, more than likely I'm going to take it a bit personal. But the lawyers don't have to take it personal. I'm not mad at Sean because Sean is representing someone who was hurt. And Sean's not mad at my client, my insurance client, because they've denied a claim. We are doing a job, and we both understand with each other that we have to, advocate for our clients to the best of our ability in a competent manner. But you should never let it get personal, because then you find yourself kind of in deep waters and acting outside of the rules of professional conduct, which doesn't make you look good to your client or to your fellow bar members.
From my vantage point, things that I do just from a plaintiff's perspective, I try to get away from the numbers early on and just try to talk to them about the difficulty of the case and some of the strengths, and most importantly, the weaknesses. That helps me make sure that I'm managing the expectations of my client, and that gives them a better understanding. Returning the phone calls is important because they're going to call a lot. And from a plaintiff's perspective, returning within 24 hours is very important because they want to hear about the case. Now, is it feasible? Some firms are smaller, some firms are bigger. So trying to make sure that we give the periodic results and know that, they're not going to hear from us every day. But that doesn't mean that work is not being done on their file. So giving them the good news, giving them the bad news, no matter if they want to hear it, talking to them about the decision-making process, making sure that they are a part of the decision-making process is important for me, because I like to let them know that I'm working with them. This is a team effort. This is a collaborative effort. It's just something that I pitch to the clients. But me being honest with them and giving them my honest opinion, and I think they trust that. I think that I never want to shy away from it. I mean, there's those times, some of the toughest conversations is, from my vantage point, of being able to sit down and have those tough conversations with a client, letting them know that there might not be coverage there, or the coverage that's there is not enough coverage to handle the devastation that has been caused to you. Those are tough conversations. Or when you're dealing with a death and there's not much coverage to be there. Those are the conversations where it's worth having, and you have to have those conversations, and it makes our lives a lot harder, especially when you're fighting as hard as you can for your client, and you want to see the good in them, and you want to see the results happen for them, but you can only do so much. And so making sure that I keep telling myself that as well is important, because it goes back to something that the bar always preaches, is making sure that we are managing our own expectations and we're taking care of our health and wellness in that standpoint. So From my vantage point, that's something important when I'm dealing with the clients.
On the defense side, communication is always key. So, you were talking about kind of explaining the good, the bad, and the ugly to the plaintiff. For us, particularly in an insurance coverage or bad faith claim, a huge part of it is that initial evaluation. Most insurance companies keep their files pretty documented. And so you'll get that initial, that claim file, and you have to go through it and you have to find all of the facts, all the relevant facts anyway. So the good ones, the bad ones, the ones that would relate to coverage, whether there is coverage or not coverage. And then you have to be able to condense all of that information and put it on paper or verbalize it to advise your client of what's going on. Because a lot of times the adjuster or the lawyer, the in-house counsel, will know something about it, but they don't know everything about it. And so you become the expert on that claim file. And so, if you catch something early, my point to my clients is, hey, if you don't have to pay me, don't pay me. But if we can get this resolved early, if there's coverage, your responsibility is to tell them, hey, there's coverage here. Now, whether or not they go with, your analysis is a whole nother thing, but being honest about whatever it is that you're doing, I think is so important, because if you're not, you will not have that client for long. With regard to providing, bad news, if something's not breaking my client's way, I tell them that. I give them some options about, what choices they can make in response. And like you said, Sean, it's important for them to be involved, even on the defense side, because they've got skin in the game. And with insurance company clients, a lot of it is a risk analysis. And so they put all of this information into some algorithm or some process by which they say, okay, well, the risk of this is higher for us to get whacked by a jury if we, rather than settle it or to settle a case. And so they rely on all of that information that you're providing to them. And if anybody who does defense work for insurance companies, they require reports every 60 to 90 days. And those reports have to be thorough because, again, they're using that information to make decisions about how they proceed in the litigation. They rely on you, they rely on the information you provide. And it's important for them to be able to make informed decisions. I mean, that goes back to the rules of professional conduct, of competently doing your job and informing your client of what's going on. And sometimes they're not going to like what you tell them. But I know that I trust someone a lot more if they tell me the bad news straight, and then we work from there, than if they try to hide the bad news and then you find yourself in a worse situation. From our perspective, from the defense side anyway, you always got to remember that it's your client's case. That's part of the rules. You work for them. They are the decision maker. And in particular with corporations or with insurance companies, this is something that's very important to them. And you need to get approval for a lot of the things that you do before you do it. Now, for, like you mentioned, like giving extensions and things like that, that's generally for us a matter of course, because you got to be civil. If you're allowing an extension, it doesn't really do you any harm. And, but big things like, oh, well, they missed the deadline to file an answer. I have to get my client's consent to extend that deadline. And that might lead to a tough conversation with opposing counsel. But again, that's something that will impact the case. But let's say, hey, they want an extension for discovery or an extension to reply to a brief, or respond to a brief. Generally speaking, I don't have any issues with those things because, again, we all run up against deadlines. We all have a lot of things that we're doing. And so, but it's always important to inform your client of that. Also, and this is very important, you never go rogue as an attorney, particularly with insurance companies. Like I said, the vast majority want to be involved in the decision making. And so if you don't get authorization for some particular, deposition or strategy or anything like that, one, you're violating the rules of professional conduct. And two, you're really building a bad relationship with that client because they don't like to be surprised. And in the insurance defense world, being surprised is one of the worst things an insurance company wants to have happen. And so the more that you can develop your practice to kind of fit into those boxes that insurance companies require, that you can check them off, the better relationship that you'll have. And like you said, man, you can't guarantee results. But you can advise them as to likelihoods. Say, hey, this is a possibility of this happening. You could lose this, but you could win this. But it's always good to kind of preface those things with, hey, juries can go either way. A judge can rule either way. But it's important to communicate these things to your client because, they don't know what they don't know in a lot of circumstances, and they're relying on you to tell them.
We had a question that said, but often the carrier is not the client. Is it the payer? Thoughts on that, Ken?
Right. So, if you're handling an insurance bad faith claim, the insurer is the client. So a lot of that, what I was saying, goes to that point. But let's say you're doing third-party work. You might be getting paid by the insurance company, but you represent their insured. And so you owe them you owe the insured the duty. That's who your relationship is with. Now in South Carolina, there was that recent case that there's some weird relationship between insurance company and insured and lawyer, such that it might allow the insurance company to sue the lawyer for malpractice for something that he did during representation of the insured, but your duties are still the same. Now, you're going to be reporting a lot of times to the insurance company, but in those situations, you're reporting facts, law, your analysis of the facts applied to the law. If it gets into questions of coverage and things like that, you can't answer them because that would be a conflict because you don't represent directly the insurance company. And a lot of times I've been in cases where there's coverage counsel and there's defense counsel. And those things can be a little bit complicated, but again, the more you communicate, the more thorough you communicate, the better those things, the easier they are, whatever obstacles you might come to are easier to overcome. Does that answer your question?
From my vantage point, from a plaintiff side standpoint, is just kind of keeping up with the current trends. I think that we always are trying to figure out what the defense is thinking, what insurance companies are thinking, my biggest thought is why you as a defense lawyer think the way you think and why you are evaluating your case the way I do for our clients and what we need to do on behalf of the plaintiffs to get better. And so I'm always looking at trends. I'm always talking to colleagues and other plaintiffs, lawyers about different types of cases because I learn from my peers. I learn from my colleagues, reviewing the legislation that is out and also looking at county trends, seeing what jurors are doing and how that's going. You always hear the trend that Charleston County is a conservative jury, or you might hear that Orangeburg is a better jury for a plaintiff's lawyer. So when I'm dealing with the cases and I'm negotiating those cases, those are things that in the back of my mind, I'm always considering, and I'm always talking to my clients about those types of stuff over and over and over again. However, that doesn't stop me from zealously advocating of it. I'm not scared, and as as lawyers, we should not be scared to try a case in Charleston County. I think we have to continue to try cases and continue to, if it's worth it, I think we have to continue to try cases.
Well, that goes back to communication, and communication is just key. And so you find yourself communicating with your clients on more things than just the status of the law or some particular fact. Like you said about the reputation that certain jurisdictions have, a lot of insurance companies or corporations who are not based in South Carolina are not familiar with certain counties. And so that information about jury verdicts and about how things are kind of done in those particular counties is valuable information to your client. And so it helps to make them make an informed decision, for them to make an informed decision. And so that's part of your job. So not only do you have to be up to date as to the status of any particular law, but you should also be up to date on kind of the goings on across the state or inside the practice that you're in, because that information is incredibly valuable. We have PowerPoints on certain counties that we send to insurance clients, just so that they know the risk that they go. So, we track jury verdicts and, kind of the ratio between your actual or special damages and what punitives are awarded and all of those types of things, because your insurance clients or your corporate clients need that information because it's business oriented for them. So they need to know, and to the best of their ability, calculate the potential risk that they're facing in this litigation. And they use that information to make litigation strategies, and B, value cases. And that's really what it comes down to, is you providing enough information as their counsel so that they can make informed decisions on how they want to proceed or resolve litigation, whether it's trial, whether it's settlement, or some other form or fashion. That information is important. My job as the lawyer is to, like you said, zealously represent them, whether it's in a hearing, whether it's at trial, whether it's at a mediation, however it is that they want, my client wants the outcome to go, I'm going to do my best within the ethical bounds to get them there. So, hey, if they want to try something, let's go to trial. If they think it's best to settle a case, then you start developing strategies with them to get it at a number that they're willing to pay. And so just being able to communicate that, and also being able to communicate with the other counsel, kind of explaining, the situation that you are in as a lawyer, say, hey, listen, my folks are really dug in on this point, and they really are putting a lot of stock on this one fact. And that's why they value the case at what they valued it at. And so you and the other lawyer can actually have a conversation about how you proceed. But again, communication is key. Your client has to know, what you're doing, where they are in the case. On the defense side, I provide updates upon updates upon updates. Again, with insurance companies, there's usually a 60 to 90 day rule where you have to submit a report. I calendar them for those days, but I also calendar a week in advance to try to get them to them early, so that you never want a client coming to you saying, hey, where's my report? You always want to be on the front end of that and providing them those things before they even request it, because again, that helps that client trust you more. And if they can trust you more, they're going to keep retaining you. And in my world, they'll pay you. So, most defense lawyers operate on a billable hour. And with insurance companies, there's a lot of guidelines of things that they will and they won't pay for. And so part of your communication is following those guidelines and billing and explaining things in a manner that's acceptable to them. Because if you make your adjuster's job easier, or if you make your in-house counsel job easier, you become more valuable. And so following their rules, and kind of exceeding those expectations. And it's not over promising. It's, hey, I can get you a report a couple days before it's due. And you surprise them with those things and they're not looking for it. It makes them look good to their bosses. And so they'll keep using you. And so that's a really important part of building those relationships.
So you just went from client retention kind of
Mm-hmm.
thing. I think that's important. One, for me, always sharpening my tools, kind of knowing what's going on. But I think from a plaintiff's perspective, a lot of, especially when you're on a smaller budget, is just making sure you're doing a good job. And like you said, you're turning in those reports. But then from our vantage point, it's calling them and giving them updates, or being proactive and, and, and and making sure that we are continuing to learn and get better as an attorney. I think I find myself every year trying to figure out different tactics or different things, and I advise everybody else to do the same thing of how we can always improve. I think got the advice earlier on that we are always practicing, because it is. I mean, every single day, it seems like no matter, I'm always learning and continuing to find and do different things that I can learn from. The biggest One of the biggest points of advice that I can give from a plaintiff's perspective, and I learned early on, just because I learn from mistakes. I evaluate each case and I learn how I want to do something better, or maybe this time I should do something. And we all, as lawyers, we get those 3 a.m. thoughts. And from a plaintiff's perspective, and Kenny, I know you get them. We wake up in the morning and it's like, man, should I did that? Or you second guess yourself, or you do not, or you're strategizing in your head, or when you're showering in the morning, you're eating breakfast, or you're riding in the car, you're always strategizing. So a lot of things that's the things that you can do, but to make your life easier, I think we have to, and I can't emphasize it enough, is making sure that we are prepared, but also preparing our clients for what goes on. I can't emphasize it enough. Making sure that things that might seem like common sense to us, the type of people that we deal with on a lot of basis, it's a wide variety. It might not be common sense to them. And so I get as simplistic in my preparation process as possible, even when it comes to physical dress, what to wear, what not to wear, whether it's deposition, whether it's mediation, or in the courtroom. Because I feel that, from a defense perspective, you guys are, I always use scouting sports analogies, and it's depositions are kind of scouting report opportunities for you guys.
And kind of to add what you said from the defense side is, you're always strategizing. You might be, riding down the road, kind of crafting an opening or crafting a closing or crafting your motions practice argument. And I think it's important to, let your client know that, when they see a bill that has those things, that they have to see the value in what you are doing in order to want to pay for it. And so, any communication that I have, or any bill entry for that matter that I have with a client, the most important thing is getting across the value that has added to the file. Because they're not going to want to pay for fluff. So, my answers are substantive. And even if I can't respond immediately to it, I say, hey, listen, I'm tied up, but I will, I'm going to turn to this. I'll get an answer for you by Monday, and then following through with those promises. But it's really about showing your value. And on the defense side, lawyers have become kind of an unallocated expense on a company's spreadsheet. You're no longer really the trusted advisor that you think of when you think of lawyers from back in the day. And so they have, particularly insurance companies, they have economic pressures because there's a lot of competition. And so their margins are paper thin. And so they want to make sure that they're getting value for what they're paying for. And part of that is giving them thorough responses. It's explaining the process to them. It's, being available to them if they have questions, or if they need to be updated. But providing that value, or expressing that value, and getting your client to see the value that you add, goes back to building that trustful relationship, and it goes back to building that bond, so that not only for that matter, they'll come back, and you'll hopefully have a long, good relationship.
Well, I think from my vantage point on the plaintiff side, there's so much information out there, okay? And you said something that made me think. We have to worry about, you talked about the trust between you and your client. And for me, from a preparation standpoint, it's so much on Google or information that's floating out there that clients think they know how to practice law. And you said you felt useless sometimes, but sometimes it's not useless, because I have to tell the clients from a plaintiff's perspective as well why you need us and how we're there to advise them, and how we're there to advise them on making sure that they're making the right decisions. Because it goes back, if it was up to them, they would not have been dressed properly. Their body language would not have been the right body language. I tell them that everything that they do when they walk into a hearing, or when they're walking into a deposition, or when they're walking into a mediation, it's being observed. And so making sure that I properly prepare for the hearing, properly prepare for that deposition, and properly prepare them for it is prudent. Making sure that the conversations that are had while they're there is so important, that they monitor what they talk about, or what they're doing, and what they say. Those conversations are being heard, and people are looking at it. I tell them all the time, especially cases that I've dealt with you on, they know that you are looking at my client. You're listening to them, even if you think that they're not listening to them. So it reminds me of those conversations that I used to have with my parents when I was getting dropped off at my grandparents' house. And I have to do that with all of my clients as well. The do's, the don'ts. And every office is different. So how I operate might be different from how you guys may operate from your practices. But I think from a ultimate goal, we are always doing those things.
Well, you're giving them more arrows in their quiver as a client. You're preparing them for the battle of litigation. And so when you advise your client as to, hey, when you begin this deposition, you should put on a tie or a polo shirt or something like that. You're helping them, and you're giving them the information and the tools so that you can best do your job. It's kind of one of those situations where you're saying, hey, help me help you. And so that line of communication goes both ways. And so it's important, I think, from any perspective, but especially on a defense perspective, that your client be able to communicate with you. Because in a lot of situations, in every situation, they're the holder of the information. And so you need that information from them in order for you to help develop a defense strategy. In defense prep sessions, you want to make sure that they understand the process. The getting sworn in, because a lot of corporate designees, a lot of times some of them have never given a deposition, and so they need to know what that process is, because a lot of the nerves are built up in not knowing what's going to happen. And so your job as a lawyer is not only to prep those folks so that they are prepared to answer the questions, but also to prepare them for the whole entire process. And again, all it goes back to competence and communication. If you focus on those things, generally speaking, your client relationships are going to be great.
Well, one of the things that I do, as you guys are always observing my clients, I'm always doing scouting reports on your client, whether it's me looking at trends from insurance companies, or whether it's me looking at your individual client and trying to find as much information as I can on them, because those things help me zealously advocate from a plaintiff's standpoint. I'm always thinking of tools of what can I do to help my client? What can I do to make the situation better? Sometimes I'm dealt bad facts, and I've already signed a case up. This, the intake process is important, but sometimes as a plaintiff, as a lawyer, sometimes we might take a bad case, and we didn't know that. And hindsight is always 20/20. And so what I do is when I'm doing my homework, I might find things out that I didn't know about your client.
Right. It's the same thing on the defense side. Part of the analysis that you're providing to your client is, how does the plaintiff present? Do they make a good witness? Are they believable? All of those things that the insurance company or the corporation or the defense will take into account when, they value the case or when they plot their litigation strategy. So, the same things on the defense side is that, that information and the importance of it, you communicating it to your client and developing that talent and that skill of being able to read someone else is incredibly valuable in developing your client relationships.
The biggest thing that I've been noticing right now, and kind of getting in more depth of kind of practicing trends and practice topics that is important, social media and the client. It's a tough conversation that I'm having with my clients early on, and I even have these conversations with them on the intake process, because they are saying, they'll get on social media, thank God I was just in this accident, but I'm okay. And they don't realize by saying that hurts their case. But I'm okay. Their initial interactions with their insurance company, the pictures that they're putting on social media, they're saying to themselves they are in this grave severity of pain. However, they just posted pictures of them working out in the gym or horseback riding. And those types of things are things that really compromise the case. Now, I can't control what a client does, but I can tell them what can harm them as far as their case.
Right. I think it's become normal from the defense perspective to always go to and search social media for whoever the plaintiff is. I look at social media from kind of a different aspect as far as client relationships are concerned, is that you have to be careful what you, the lawyer, put on social media and the type of things that you represent. Because, if everyone has access to whatever social media you have and you're putting, compromising pictures or anything like that on there, a lot of times that'll cause a client to walk away because they don't want to be associated with that. A lot of big companies and insurance companies have a culture. And if they're loyal, they want their counsel to line up with their culture. And if you don't, then you won't be working for them very long. So it's very important that you use social media and you use advertising in a manner that's dignified and not harmful to your careers, to put it bluntly.
Are you looking at, you mentioned that, but are you looking at it from a standpoint of, are you looking at your opposing counsel's social media, or because when I come from a social media standpoint, I'm always telling the clients as to what they should do and what they shouldn't do, because it's going to come back.
Right. I don't look at the other lawyers' social media. You know, a lot of what you need from them, you can just pick up the phone and call them. I don't think you really get any kind of decisive advantage in a case based on their social media. But, you know, a lot of what we put into these reports that we send to our clients are things that are included on their social media pages. You know, like you said, if they're saying, hey, you know, I can't walk, but then they have a video of you running on the treadmill, that's going to hurt your case. Or, you know, if you've described an accident, you know, it's happening one way, but you video everything these days, and that video shows that it happened a whole different way, that's going to impact your case. And so part of being a good lawyer is being able to find the information if it's out there, and then being able to process it and understand how it helps or hurts your case. You know, a lot of insurance companies, they don't have social media accounts, you know, or if they do, it's very bland, and, you know, it goes through 3 departments before they post anything. So I, from a defense standpoint, don't worry about that as much because it's not an individual. And so the way their public facing side is, generally speaking, very thought out, very pre-planned, and follows certain guidelines. So, you know, they're not going to talk about, hey, you know, we denied coverage in 8 out of 10 of these cases, and guess what? It made us, you know, $1 gazillion. That's not how they do. So it's very different from our side of the bar. We use social media more as a weapon for us, I think, more so than plaintiffs can against corporations. Now, again, individual defendants, if, you know, you're in a third party action, I advise them too, hey, don't put anything on social media, because it, like you said, it can hurt your case.
From other trends that I'm noticing, and I know you have some trends as well, but some of the trends that I'm noticing, been getting calls, and we have to be mindful from that standpoint. It goes back, it's an extension of the social media topic, but investigators looking at clients. I see it a lot more in a lot of personal injury, and I'm seeing it in the workers' compensation realm, where I will get a call from an insurance adjuster and they will say, hey, or I'll get an email or a letter sending pictures of a client moving furniture when he said his back was hurt. And, you know, you can't be with your clients 24/7, and your clients will never tell you everything. They probably won't tell you mostly 50% of everything. You know, you're always going to be learning something new from your clients. Every day you're going to be learning something new from them. But I have to tell them to be mindful that they are being investigated. You know, if they are saying that their back is hurting, that you might have some pictures that populate that say something different. So that's a trend, and I don't know if any other plaintiffs lawyers out there have been seeing that particular trend, but that has happened a lot lately, and probably at least 3 times in the last month. And from my experience, what that happens is sometimes I see that trend a lot more, but now it's here, and then it might go away. But now I'm starting to see it a lot more of people actually still doing that. So I try to make sure that they're mindful of those investigations that could be going on with them.
Right, and, you know, using an investigator is just another tool in a defense lawyer's toolbox. You know, if again, it's the client's decision. You know, we have to get approval most of the time from any client to pay for or to retain an investigator. And, you know, you have lots of conversations about what their scope of work is going to be. So, you know, how long they're going to monitor, when they're going to monitor, what types of behavior they're monitoring for. So, you know, as a lawyer, it's important to be able to identify when one is needed. If the injury is clear and there's really no dispute that the person was hurt, then you're not going to need an investigator. And the same thing goes for an expert, is that you have to be able to recognize when you need one, and what type of expert that you'll need. And you have to present that to your client in order to get approval for you to hire them. Again, on the defense side, everything's kind of an unallocated expense. And so companies are really particular about what they're going to pay for, and they have to see the value of it. So if it's a personal injury case like you were saying, where I check Facebook and I see your guy doing X, Y, or Z, it might be worth putting an investigator on. But in other types of cases where the injury is clear, there's not really any doubt whether or not they're malingering. And so you don't need one in those cases. And I think it's about, again, being honest with your client and having them involved in the process, and so that they have skin in the game. And that's a weird thing to say as a lawyer, because the cases I have are not my cases, they're my clients' cases. And so you have to communicate to them so that they understand this is your case. And so you need to be involved in the decision-making processes. And here's why I think we need an investigator. This is the benefit I think it'll give us. Or here's why I think we need an expert. We suspect that the accident happened this way. An expert's likely going to confirm that. And so you can get the case thrown out, or you can, use it as leverage to resolve a matter in a way that's most beneficial to your client.
A lot of trends that I've seen have been related to COVID of this year alone. And so whether it's on the workers' comp side of things, whether or not you're dealing with employees that have been injured, and now they're saying that COVID was on their job, they received COVID by their work. Everything from COVID, from what I'm seeing, we have to go back to law school and get with the facts. Those 1L years of facts is important in this COVID litigation. From trends that I've been noticing, even from my office, especially from the workers' comp standpoint. One, timelines of tracking down everything, because it's impossible for us to know where a person received COVID from if it's in a workers' compensation standpoint. And so that's difficult. However, from a timeline and a factual standpoint, it's different. And a trend that I'm noticing is that, there are protections out there for certain people, especially like law enforcement, with regards to COVID, that might not be there in the private sector. Another trend that I also noticed from COVID alone in this particular year are some of the trends with the nursing homes. A lot of people, from a plaintiff standpoint, we're always paying attention to the legislation that's going on. And I know there were talks about COVID legislation from the state standpoint and also the federal standpoint. But I intend for us to continue to see the trends, and I think that there's going to be a lot more litigation when it comes as a result of COVID-19. Even from a standpoint, from a plaintiff standpoint, from representing business owners, and as you can see from corporate side of things, we're getting calls from business owners and businesses who have not been able to retrieve their business interruption insurance, and dealing with those coverage issues, whether or not COVID would fall into their policies. And those are types of trends that I've saw and been getting calls about, and have been analyzing and trying to figure out, and still working on it as we speak.
There's, on the defense side, there's a couple of ways I look at it. Of course, COVID threw everybody for a loop. I mean, it shut down the court system. It, caused a lot of people to have to work remotely. So you don't have the normal resources that you generally would have working inside of your office with your staff being there. So part of my job as a lawyer on the substantive side is to make sure that you're staying up to date with the status of the law and what other courts have decided with regard to coverage for business interruption, for for any type of insurance claim, so that you can advise your client, hey, this is what we're seeing. Secondly, from a client relationship perspective, it makes you have to have some understanding. You have to be adaptive, because a lot of insurance adjusters or corporations are working remotely, and so you might not get as quick of a response as you're used to having, or it might work the other way, is that they have nothing else to do all day. They have no other distractions, so they can reach out to you and communicate with you whatever questions they might have, more so than they did prior to COVID happening. And from the defense side, it's important to understand what COVID has done to any particular practice of any client. So, if my client is is in the food and beverage industry and it's a restaurant, I need to understand what COVID has done to that business, so that you can, in whatever particular case, take that information, process it, apply it to those particular facts or that particular circumstance, so you can advise your client saying, hey, listen, with where you are, it might be best to settle at this point, or to make any other choice. So I come with a holistic approach. It's not just the substantive part of the law to say, hey, this court in the Columbia division dismissed this case because they said there was no coverage, your policy is the same. It's also, hey, I know that COVID has shrunk your profit margins, and so I'm going to be even more particular about how I bill things, because I know that you are going to be sensitive to that as a client, and it might cause you to change your fee arrangement. You might go to a flat fee, or you might reduce your rate. But it's those types of things that you deal with when you're thinking about developing and maintaining a client relationship. So the things that go on the outside world, whatever impact they have on these businesses or your clients, is likely going to transfer to you in some form or fashion. And that's what I found about COVID, is that whereas before they were willing to pay for 2 lawyers and a paralegal on a file, now they just want 1 lawyer. And so you have to make do with those things, and you have to be adaptable, and ready to change things up in order to meet their needs, whatever they might be.
Kenny, what I've been seeing, and to everybody listening, ride share liability. I think right now we live in the age where convenience is more important, and everybody is trying to stay safe, and they're using ride share a lot more, probably now more than ever. And from the plaintiff standpoint, we can't really say names or anything like that, but I think ride share liability is a trend in the market that us as lawyers have to look out and listen for more so now than ever. And it's not from just a general car accident standpoint, but also from a standpoint of safety and procedural background checks on the drivers and the conduct of the drivers, because you might have a situation where a driver assaulted somebody, and now you have to put one of these rideshare carriers on notice, or a driver stalked somebody, or and so now you're dealing with trends in that regard, whether it's an intentional tort or whether or not you can find liability on the rideshare companies. But I see that trend happening more and more. I think we have to be mindful of the background checks of the drivers. We need to know the differences in the policies. We have to study the rideshare carriers' policies, because they are different, and at different points, different policies are triggered. And so we have to make sure that we are reading those with a fine-tooth comb. And not only from car accident standpoint, and not only from a conduct standpoint, but from a food poisoning standpoint.
Well,
But it goes back to the conduct standpoint.
well, and I hate saying, because I keep saying it, it goes back to being competent. So with the rideshare trend, again, because more people are using it, you see more accidents, you see different things. So you want to be up to date with the status of the law, of whether or not the jurisdiction that you're in sees the driver as an employee of the rideshare, because that changes how you litigate a matter. It changes who you potentially name as a defendant. It changes how you defend the action, whether or not that driver is considered an employee or not. In places where that's undetermined, that can be used as leverage on either side to say, hey, well, you don't know what a court's going to say or what a court's going to do, but you have to be up to date as to that status. I know South Carolina has a ride sharing statute that provides a whole bunch of definitions and requirements for ride share to protect the general public. So it's always good to be cognizant of the status of the law, because if you're not, you're either not going to be able to advise your client properly, or you're going to get it wrong and the client will get whacked. And again, they won't be your client for long, and you might have a malpractice claim on your hands. But the ride sharing industry is certainly interesting. I know, I've dealt with certain coverage issues about ride sharing, of when coverage comes into place. And you base that on the statute, because there was a huge argument here. Well, does the ride begin once you order it on the phone, or does it begin when you actually physically get in the car? And so, those are interesting questions, because there are different policy limits that would apply if there's coverage or not. I mean, if there's not coverage, the driver's own personal insurance is going to be on the hook. If there is coverage, then the ride sharing insurance company, their coverage is going to be on. And so you need to know those things and how that state, or your South Carolina in particular, views those things, and how they define, when you have held a ride share, or when you become a passenger, or when that fare begins, in order, so again, you can communicate to your client. So when there's an incident, you can actually advocate for them, you can advise them, and you can work with them to develop a strategy about resolving the case.
And I think from my standpoint, from the plaintiff side of things, I'm always looking at negotiation tactics. I'm always looking at tools of negotiations and things like that, or tools as to what can be negotiated and what can't be negotiated. But I think the confidentiality is a negotiable proposition from a plaintiff standpoint. I think that gives us an added value to add to your case, whether it's in a ride share situation or any types of cases. I always try to make sure from a plaintiff standpoint that the clients know the value of confidentiality or not confidentiality and those things. So I'm always looking at the defense, and I'm always looking at things that I can negotiate for to give my client value, and whether or not I can use these documents or reports in the future to help me with future clients and future problems and future trends that might arise.
Right, and again, it goes back to being confident. On the defense side, generally speaking, my clients do want a confidentiality agreement in any kind of release that they have. So if they settle a case, they don't want, a plaintiff to be able to go out and talk about the amounts or anything like that. And so, a thorough attorney is going to make sure that, you communicate that and that's worked out. Because your client's going to have certain expectations, and you need to make sure that what those expectations are, and you ask those questions. You say, hey, listen, do we want to include confidentiality? Is that going to be worth any extra consideration to you if the plaintiff pushes back? But it's about having all of those conversations up front, and kind of pre-planning and prepping your client of what to expect that again goes back to building that relationship. And so, of course, the confidentiality requirement and the rules of professional conduct, anything that my client and I talk about, I'm not going to broadcast. I'm going to keep all of those things confidential. And it's important for them to know that you know that. Because again, I wouldn't want to hire a lawyer who's going to have all my business in the street. But as far as using, those clauses in an agreement or anything like that, it's something certainly that you want to advise your client of on the defense side and say, hey, listen, they're saying they're not going to sign anything with a confidentiality agreement. Maybe we do X to sweeten the pot so that they will. But it's all about, again, communicating with them and catching those things before they become a problem.
And we've been talking for a while. Are there questions for us?
One other additional trend that I thought has been pretty interesting is the use of time limit demands.
I'm sorry.
There's a lot of kind of consternation between the defense bar and the plaintiff's bar with time limit demands. From the defense side, we've always taken the position, that those Tiger River letters and those time limit demands, that was meant for a shield for the insured. But now it's kind of become a sword that's used against the insured. Say, hey, listen, you've got 3 days to send me your policy limits or the deal's off to settle this case, and then I'm going to go after you. So the kind of dichotomy there has always been very interesting to me. And, a lot of times when you get involved, you're able to say, hey, listen, my folks need to do some investigation. Can I have an extension on this? But the use of those things as a sword has been very interesting to me. And the other trend that I've noticed, or it's starting to kind of crop back up, is the use of a John Doe to defeat diversity jurisdiction, removing a case to federal court, especially in those counties that nobody wants to be a defendant in. So, you see that they name you as a defendant, but then they name a John Doe and they allege in the complaint that the John Doe is from that town or from this state. You, the person who's trying to remove the case, carry the burden. And so you see, different courts handle the fictitious defendant in different ways.
And that's what you find from plaintiffs, from our standpoint, trying to keep things out of federal court.
Right. I mean, all of those things matter. And, my initial reports, there's generally categories that you cover. So you cover your jurisdiction question. So you provide your client with information regarding that jurisdiction. What the jury pool is like, what their education is. I mean, they're very, very thorough. What the poverty rate, the economics are in that particular county. You advise them as to whether or not you believe the case is removable. And you want to explain to them why you think it is removable and the advantage to being in federal court if you're a foreign defendant. And then you talk about the facts of the case. You talk about the status of the law. You analyze that. If they request it, I provide an analysis on, settlement value. Even sometimes they ask you to give a report or to analysis of the opposing counsel. And so, everything kind of has been broken down into numbers, into information. So all that information is important to these companies and these clients because they use those statistics to evaluate risk. And so lawyers have to be able to provide them the information or to help them calculate that risk in a manner in which they do it. But, the removal issue and the time limit demand issue are all things that I talk to my clients about and say, hey, listen, we've received this time limit demand. Here's what they're asking for. Here's what it means if we don't meet it. Here are our options, and then you provide your options and you explain it, and they can make an informed decision from there. whether or not you can remove a case to federal court often informs, the value of a case to a client, particularly an insurance company, because they're familiar with those things. Because every state has better jurisdictions that they believe are better than others. But all of those things, a good lawyer, a competent lawyer, is going to be able to talk to their clients about, because that information these days is necessary.
Any other trends before we get into questions?
No, you covered the COVID, just seeing a lot of different things with that. Yeah, I'm happy to answer any questions that might be out there.
Yes, guys, if you have any questions, please ask us now.
I've got a question, Sean, for you on the plaintiff side of things.
Okay.
How do you generally communicate things? Is it more phone calls for you, or do any of your clients want something in writing as far as reports to kind of provide them an update?
From a plaintiff standpoint, the reports from my vantage point comes more so from phone calls, communications, and we have it calendared in from periodic telephone. Motto that we have in the office is to call the clients before they call you, because 9 times out of 10, if a client is calling you, then there's probably an issue, and so I'm always trying to call them beforehand. So I make calendar alerts and call them as much as possible. But a lot of communication is important. And we have one question from Emmanuel Ferguson. He says, what is the best way to politely and effectively tell a plaintiff's attorney he or she is overvaluing his or her case? Also the inverse from a defense standpoint. I think that comes from my vantage point, Emmanuel, I think that comes from just an experience standpoint. I think the more you practice, the more you know a case's value and a case's worth. And so sometimes we have to, one, always remember that it's not our case, it's the client's case. And we can't put our own expectations in the case. And then two, make sure that we managing the client's expectations of the case. Sometimes we do get in a situation as a plaintiff's lawyer where no matter how much we try to manage an expectation, a client is going to want what that client wants.
Well, and what I've seen it done several different ways. Some people are blunt and they say, hey, listen, I think your guys you're overvaluing this case because of XYZ. What my general strategy, because our jobs are confrontational enough, is I'll say, hey, my client is stuck on this fact. And because of this fact or these any number of facts, they don't value it the way that your person values it, and we think that's overvalued. You're not considering X, Y, or Z, or are you considering that? And I would assume I would do it, and I have done it in the inverse side the same way, and say, hey, listen, my guy's he keeps talking about this light being red, and the police report says that it was red, and he's got XYZ, and these juries have been awarding this type of verdict. So this is how we've come to this number. The fact that your folks are, at half of that doesn't really make much sense. Can you explain it to me? And for me, it goes back to being able to communicate with counsel. I want the other side to trust me as much as I want my clients to trust me, because they need to know when I tell them, hey, that's all the money I've got. That's what I mean. And so there's any number of ways to do it. I usually take the roundabout way just to say, hey, my client is stuck on this. so that it doesn't sound as if it's a personal issue between myself and that other person.
And we have another question from Chris Jacobs. He says, regarding motor vehicle accidents, can you give an explanation of gap insurance versus underinsured motorist insurance versus uninsured motorist insurance, i.e. the difference in application of each? Sure, and Kenny, chime in if you want. Gap coverage is important, and it's something that it's sold when a person purchases a car, and they have the option, if they didn't buy it when they purchased a car, to get that covered from whoever they're financing the car with, or sometimes insurance companies is what you would see. So gap coverage is to say, if your car is totaled out, that insurance coverage will come in and supplement the value. So let's say, for example, your car is totaled out, and the value is of your vehicle is $20,000. The value of your loan is $20,000. You owe $20,000 on your vehicle. If you get into an accident and total your car, your loan is $20,000. However, your car is a 2013 Honda and you signed a bad deal, or you got what you could afford or finance for. The car is worth $13,000. So instead of you or the client having to be liable for that $7,000 difference, gap coverage would come in and say, hey, we're going to pay the remaining balance of that loan that you have. And that's gap coverage. Now, underinsured motorist coverage in South Carolina, you are required to have, the minimum limits is $25,000. Something that I always counsel clients about, even in the counseling standpoint, I talk to them about their insurance policies when I'm looking at it. Why they should have this, why they should have MedPay, why they should have this. And I talk to them on looking at their finances and how they should adequately protect themselves. So underinsured motorist coverage is important to have, because the majority of the people that you are riding around with on the roads might only have $25,000. So I tell the clients to say, hey, look, protect yourself and get some underinsured motorist coverage. That way, if something happens to you, you can always supplement it. I look at it as a supplemental insurance coverage, the way you make sure you have more than enough coverage to protect yourself from your vehicle property damage or your bodily injury damage. And then you got uninsured motorist coverage. That is what's going to protect you against a driver who has no insurance coverage at all. And South Carolina requires that we all have uninsured motorist coverage of at least $25,000. Then if I look at the clients and I see they have more assets, I say, hey, look, you might need to protect yourself a little bit more. And so that was the differences from each of the applications from the types of insurance. And
I'll add to that just simply that, from my perspective, it's a lot of times whether or not the insurance company made the actual offer, because that's what's required by law, is that you make the actual offer and they can decline getting underinsured or uninsured motorist insurance, because that's going to impact the case. A lot of times you'll say, well, I've been in cases where they sue the insurance company and say, hey, listen, I asked for uninsured motorist coverage and you didn't give it to me. And then I got in an accident. I thought I had particular coverage and I didn't. And so, you want to make sure that your clients understand what that meaningful offer is under the state's particular law.
The Wanamaker test.
And there's another question: how do you handle claims regarding vehicles damaged by debris in the road? It depends on who's responsible for cleaning up the debris in the road, who left the debris in the road, if you can identify who that is. And
sometimes it could be the highway, the South Carolina DOT, Department of Transportation, or the local counties. If there's notice is kind of the big thing on that debris in the road. If there's notice, Kenny and I had a conversation about an act of God a long time ago. Sometimes if it's an act of God, it might not be anything that you can actually do.
Right, and it, like anything, it's fact specific. So, the short answer is A, whether you can identify, who is responsible for the debris, so you know who to bring the claim or the lawsuit against. And then B, once you can identify them, you can determine whether or not it was because of some negligence or because of some act of God or anything like that. But there's a lot of investigation to be had on the front end. I think the important thing as far as, the topic of ours is being able to communicate that to your client, because, they might walk in thinking that, hey, this is slam dunk, $1 million case, and it might not be, because, again, you have to investigate it thoroughly so that you can provide them kind of what the chances are of success on the merits of the case.
And thank you, Ms. Renee Anderson, for sending that question in. I hope that we were able to answer all of your questions. We still got some time, so please feel free to ask any questions that you might have. And Kenny, I got a question for you, just from a defense standpoint. And you may have touched on it a little bit when we were actually talking, but what do you do more so when you have bad facts, when your client has a bad case and the plaintiff has a more of a stronger case? How do you let that client know, hey, I think what is that conversation like for you?
I mean, I don't want to say it's a difficult conversation. It's just a conversation. A lot of times you're putting it in your report. And so you want to be as detailed as you possibly can. I often will, I'll refer to a medical record and then I'll attach it to my report as an exhibit so that they can have ease of reference to it to know, what fact that I'm talking about. Or, this person clearly has coverage and, they made this claim and you didn't do enough to investigate it. You want to put those things in very specific terms, because again, in most of those cases, the adjuster that you turn it into is going to elevate it and send it up the corporate ladder to whoever it is that makes those decisions. And they need to have as much information that they can quickly get to as they possibly can in order to value it and to make some decision about what it is that they want to do. Generally when you have bad facts, you argue the law. There's always an argument, but you want to use that information to say, hey, listen, the likelihood of us succeeding, or getting a defense verdict has gone down with these facts. But the important thing is that you provide that information to your client as quickly as possible. Because, let's say you saw it in the report, but you didn't say anything about it until 2 days before the mediation, and it increases the value of the case. They're not going to be able to do anything with that information because it takes time for them to send it up the ladder and for the decision makers to say, okay, yeah, we'll increase your settlement authority by X amount of dollars. Or, all right, well, we won't put this witness on the stand because, they gave this statement previously. So you need to be able to communicate those things to your clients as quickly as you can so that they can have it to make the decision. And that's how I do it anyway.
There is a question in the Q&A box, and y'all can submit anonymous questions through the Q&A feature. But the question is, any advice on how to restart settlement negotiations after previous early negotiations were unsuccessful? I don't want opposing counsel to think I'm desperate for settlement, but I think more discussion should be had.
I smile because Kenny and I just had this conversation yesterday, and it's a tough question. I think that's a good point from a plaintiff's standpoint. I think we have to zealously advocate for our clients, and we have to re-engage that conversation. But I think from our standpoint, from a negotiation chip, let's go back and evaluate our case and see what new that we can bring to the case as a strength. That way, when Kenny goes to his client, he can say, Sean brought this to the table and he's going to do X, Y, Z, and they can seriously evaluated or not. Would you agree?
Yeah, and there's several different ways you can approach it. It depends on the relationship that you have with opposing counsel. So if your client wants you to attempt to reopen negotiations without sounding desperate or giving the farm away, if you have a relationship with that person, I can pick up the phone and call Sean and say, hey, listen, my folks are interested in this, but again, they're cross stuck on this, and a lot of times honesty in those situations help. Say, hey, listen, they've put this much money on it. If you'll agree to it, I can get that. If you don't have that relationship, it's always that's the whole purpose of a mediator. Generally speaking, I've had more mediations end without settling the case, and that's no comment as to the skills of the mediator, but that's just how it goes. You're putting your case on the table and you're getting a feel for it, and the negotiations continue after the fact through the mediator. So a lot of times if negotiations have broken down, you can call the mediator and say, hey, can you anonymously kind of reach out to the other side, and don't tell them that we want to reopen it, but talk to them about reopening the case, and if there's any interest, and can you let me know? And I think I've worked with a lot of mediators that have been incredibly effective at continuing the negotiations after the fact and breaking down those communication barriers between the parties.
We have any other questions?
I don't see any in the Q&A box.
Well, if anybody does have questions, feel free to give me a call or email me. My email is Sean, SEAN, @SeanWilsonLaw.com. That's Sean @SeanWilsonLaw. And my office number is area code 843-242-7622. 843-242-7622. If you have any questions about what we talked about or just want to generally strategize, please feel free to give me a call.
Same with me. If you got any questions or if I can ever be any help, my email is kenny.gardner@butlersnow.com. And my direct line is 843-277-3703. Sorry, I don't call myself that much. Thank you, Christy.
Thank you, Christy. We appreciate it.
Glad we could be of any kind of helpfulness.